Rob Christopher is an AV preeminent rated litigation and trial attorney who served as Northern California managing partner of international law firm Couder Brothers and later litigation counsel with the Bay Area law firm Hopkins and Carley. Currently, he is general counsel of his family's farming business, Christopher Ranch LLC, and founder and managing director of independent neutral service, Just Resolve LLC. Rob earned his JD at the University of California at Davis and an AB with honors in economics at Stanford University. He has also been a mediator, arbitrator, and settlement judge in California Superior Courts and is admitted to practice before numerous federal district and appellate courts and the U.S. Supreme Court. 43 years married and now a grandfather of four, over the last decade, Rob has developed and now champions a new approach to delivering cost-effective justice in common, limited-stakes legal disputes using a neutral-driven, non-adversarial resolution process, NDR. Learn more at www.justresolve.com.
Hi, I'm Rob Christopher, and I hate boring ethics MCLE programs with a passion. So I've tried to craft one that I think you'll find different, genuinely interesting, and useful in your practice, especially in the context of civil dispute resolution, avoidance, and mitigation. And by interesting, I mean interesting enough to actually listen to and maybe make a note or two about it for later use, instead of just running this 1 hour recording in the background as you do other work. In fact, I'd go so far as to say that if you buy into even half of what I describe and suggest in this program, you will do a better job of, one, obtaining and assuring your clients informed consent to action plans. In other words, it will help protect you from after-the-fact claims that you failed to inform them of the risks and benefits of alternatives to the course you agreed on. It also will help your clients get better net outcomes, and it will help clients appreciate your commitment to their best interests and thus become more loyal to you. In order for you to evaluate my claim of all this potential usefulness, I should share up front a little about me. I've been a lawyer for over 40 years, most of them as a civil litigator and later partner in an Am Law 100 law firm, but more recently as general counsel for my family's farming business. I've represented defendants and plaintiffs in a wide range of lawsuits, settled hundreds of cases, tried numerous different kinds of cases, and written or advised on a lot of contracts. So I've probably been in shoes like yours, and probably, like you, I've often faced what I believe is both an economic and ethical dilemma with our legal system, especially in court, but also via alternative dispute resolution, or ADR. The first, or economic part of this dilemma, is that all too often our legal system fails to deliver economically rational civil justice to our clients, because the combination of, first, the legal costs necessary to litigate in any forum, and second, hidden costs like lost and distracted time and damaged reputations and relationships, not to mention stress, they conspire to make real justice simply unattainable, especially in cases involving what I call limited stakes. The second, or ethical part of this dilemma, is that we attorneys too often fail, I think, to adequately warn our clients in advance of these economic risks and of the full range of alternative paths that they might pursue. Before I go further, let me define what I mean by limited stakes dispute. This is a dispute which does not make economic sense to litigate, because if the parties litigate, each side is likely to have to spend more in legal and hidden costs than the difference between them in dollars. That is, the financial stakes that they have to gain or lose. Incidentally, as a practical or general rule of thumb, I think almost all disputes about money damages below $500,000, I think of all of these as having limited stakes, though the range of what are limited stakes really lies in the eye of the beholder. And I've seen many different attorneys in different situations put different numbers on what they would call limited stakes. So it depends on the beholder and it depends on the circumstance of the dispute. So the limit or range can vary among persons and companies. And I lay no special claim to the magic of the $500,000 number, except for the fact that in my research and investigation of our litigiousness in society, it appears that more than half by number of the civil money disputes that occur every year in our society fall within or below that $500,000 limitation. Disputes of higher amounts usually are what I would call high stakes disputes, where it may be worthwhile or make sense to litigate in certain circumstances. In any event, my practical definition means that many, if not most, common civil lawsuits are in fact disputes over limited stakes. So I decided not too long ago to dedicate the later years of my career to doing something about this frustrating dilemma. Specifically, what I have done is to explore and develop an innovative yet relatively simple approach to resolving limited stakes disputes that delivers reliably fair, fast, and cost-efficient justice to parties who agree to use it. To grow awareness and use of this approach, I've founded a neutral dispute resolution service business named Just Resolve. I've written a book available on Amazon and Barnes & Noble titled Just Right, and I take every opportunity to write or speak about this approach, which at heart is an innovative method of alternative dispute resolution, or ADR. I will describe it for you in detail later in this program. Of course, because this approach requires the parties to agree to it, just as traditional ADR methods like arbitration and mediation do, my method won't work in all cases. But I believe that every client-centric lawyer among us will find that whether or not it works in a given case, it often will be worth you considering it and at least discussing it with your client in limited stakes disputes, because considering it or something like it will all but guarantee your compliance with our high ethical duty of informed consent, and thereby reduce the risks of serious adverse consequences if we were to fail in that duty. I will also describe in this program another helpful tool for use in the context of meeting our ethical duty of informed consent, a tool which I've constructed and come to rely on while developing, refining, and using the new method of ADR mentioned a minute ago. Although the usefulness of this other tool will be evident for any informed consent analysis and discussion. I hope you will find both tools and this program worthwhile. Just so we don't get lost, let's start with a quick review of the ethical duty of informed consent. We all know that informed consent is the agreement by a client to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct, so that the client can make a reasonable, informed, and deliberate choice. See, for example, ABA Model Rule 1.0e, and California Rules of Professional Conduct 1.0.1 and 1.4A2 and B. Every set of professional ethical rules of conduct issued by every state bar in the United States, and also those in the ABA Model Rules of Professional Conduct, includes this concept and requires that we as attorneys obtain such informed consent when proposing or recommending a course of action, such as a strategy and process for resolving a client's dispute. In short, people are entitled to know their options, their reasonably available alternative courses of action, and the advantages and disadvantages for each option. And it's our professional duty to deliver it. Indeed, as lawyers, our ethical duty to obtain this informed consent of our clients to any proposed course of action is among the most sacred and highest, if not the highest, moral responsibility we have. And I realize that this is not news to 95 or even 100% of you out there, but it's important context for the balance of this program. And I'm hoping that some review of this and of the consequences of what we do and say with our clients when it comes to this duty will be of value to you. Of course, there are some significant variations among the states. Here's the ABA model rule, Rule 1.0E. Informed consent denotes the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. Rule 1.4B. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Note that the ABA rule explicitly requires lawyers to disclose reasonably available alternatives to whatever plan we propose, or whatever plan our client might even initially favor before going through this analysis. Some states adopt the ABA model rule, some modify it, and some go their own ways. For example, Maine Rule 1.0E adopts the ABA model rule mandating disclosure of reasonably available alternatives, and then further adds that lawyers must explain, in quotes, the advantages and risks involved and any other circumstances bearing on whether the client has made a reasoned and deliberate choice, close quote. On the other hand, California Rule 1.0.1 does not adopt the ABA rule, and instead requires only that the lawyer explain the plan's relevant circumstances and material risks, and, per Rule 1.4A2, the means to achieve the client's goals, while another rule, 2.1, allows but does not require consideration of economic, moral, and other factors. In short, Maine takes a broader client-friendly approach, like the ABA model rule that expressly requires weighing alternatives and their respective advantages, while California appears to take a narrower, attorney-friendly approach that arguably gives attorneys more latitude in what they must take into account in meeting their duty. Regardless what variant the informed consent duty applies in your state, we all face practical challenges in meeting it. To put this in context, let me analogize for a minute to the medical field, where doctors have a comparable duty, as we all well know. An orthopedic surgeon looking at a torn ACL on the knee may recommend immediate surgery based on training, experience, Hippocratic oath, and or possibly, realistically, even incentive to make money. Nevertheless, he or she is duty-bound to explore the patient's circumstances, course and costs of treatment, prognosis for recovery, and the like, and then inform the patient of reasonably available alternative procedures or therapies that might better serve the patient's overall best interests, ultimately allowing the informed patient to decide the best course for him or her. Of course, to do this properly, a surgeon must keep up to date with new and alternative approaches, including their characteristics, advantages, costs, and risks. To be sure, some surgeons are more informed and diligent in exploring alternatives than others. Like surgeons, lawyers who litigate commonly consider or can be influenced by their training, experience, desire to help, and realistically, their incentives in advising whether and how to litigate. I have found, however, that we often are not so good at considering and disclosing creative paths to dispute resolution that rely less on our expensive skill sets, nor are we especially diligent at disclosing and comparing all pertinent factors and costs of known or creative alternative paths. One reason is our natural incentives. Litigating is what we know, what we're trained to do, what we have experience and expertise in, and what we make money doing. So these first three factors or explanations for overlooking, ignoring, or underplaying other paths forward are pretty self-explanatory. Now let's add to those first three factors that law schools do not teach how to save clients time, money, and frustrations. That's not their curriculum. Law schools don't give instruction in determining and balancing the costs and value of vigorous advocacy in light of financial stakes and other considerations, or in finding and using creative and non-traditional alternatives that may more effectively make justice accessible at a reasonable cost. Lawyer-driven mediation and arbitration are taught in law schools today, but those alternatives fall well within the box of law, legal process, and advocacy. In other words, tools that only lawyers can wield in most states. In short, there is little training or incentive for attorneys to inform clients of reasonable and alternative outside of the box paths that could achieve client goals while saving clients time, money, stress, and frustration. A related reason why we may not fully cover alternatives is that the billable hour and other financial incentives drive young lawyer on-the-job training. Few are the law firms that explicitly or even implicitly teach client centricity in the course of attorney-client informed decision-making beyond the simplest equation of whether to settle early if possible or choose to litigate. Another reason we can falter in exploring alternative paths with clients before pursuing litigation is that we often don't feel that we know enough about the facts of a dispute at its outset in order to evaluate and recommend a specific settlement or other course of action. This can be a very real obstacle. We certainly don't want to risk a poor settlement, commit malpractice, or make some other mistake by prematurely offering or accepting a worse outcome for our client than necessary. And until we get and give up important discovery, we're often not really sure who or what to believe, or even how to deal most effectively with opposing counsel. So we default to litigation early on while we learn, thinking that litigation gives us and our clients control and protection against premature and wrong assessments that could be faulted later or leave money on the table. What we don't do often enough or well enough, however, is weigh those uncertainties and their consequences against the foreseeable legal and hidden costs of pressing forward with broad discovery and the gamesmanship of litigation. If we were to do that kind of weighing, we might well find a more creative path to recommend that laser focuses on key facts and law that will make the most difference in the final outcome and in its costs. For example, sometimes a single overriding disputed factual or legal issue can be made the subject of an early or interim mediation or arbitration. I personally used this approach in one employment case where that key and hotly disputed issue was whether a plaintiff's prior participation in a class action settlement effectively released his subsequent specific employment claim for unpaid overtime. Published case law in that instance allowed for argument on possible different interpretations on the issue. So in that case, both sides were looking at spending hundreds of hours and tens of thousands of dollars on discovery and maneuver until we realized that this one issue would effectively decide if the case was worth either a nuisance settlement of about $24,000 in that instance, or if the case would likely result in a final settlement or judgment of more than $100,000. So the parties agreed to arbitrate the legal issue and negotiated what the settlement amount would be depending on who won on that critical legal issue. The one issue arbitration cost each side only about $10,000 from beginning to end, and ultimately saved each side at least 10 times that, while delivering a largely principled outcome. Incidentally, the arbitrator in that case, if you're curious, found that the release did bar the later claim, saving the defendant about 5 times more, or about $75,000 in avoided liability. A similar reason for not fully and comparatively informing our clients of their risks and options is that many attorneys don't know, and some pretend not to know, what the likely total costs of litigating a specific dispute will be. The pretenders know that any realistic or objective estimate is likely to reveal the economic absurdity of litigating a common civil dispute. However, many attorneys just find reliable estimates of any judicial process difficult to make. Even in cases to be arbitrated or mediated, it can be challenging to predict future costs because the nature of adversarial process involves many variable and interactive factors. In binding arbitration, for example, despite streamlined discovery rules and the absence of a right to jury or appeal, there is still tremendous room for variation in time and cost as advocates take focused discovery and maneuver for advantage. In mediation, for all its potential advantage in reaching a fast settlement, often is ineffective before important discovery and maneuver have played out. And mediation is traditionally a non-binding process that, if it fails, simply adds to the total costs of litigation. In any of these 3 litigation contexts, or adversarial contexts, therefore, court, arbitration, or mediation, future legal costs may seem largely unpredictable except in a truly ballpark range. Add to that uncertainty that almost universal failure of attorneys to even think about how to measure likely hidden costs of litigation, such as distracted time, loss due to delay, and injury to relationships and reputations, and any effort to project comparative total litigation costs of alternative paths may be daunting to most attorneys. Finally, our culture suffers a pronounced bias in favor of lawyer-driven litigation to resolve legal disputes. Rather than undertake an objective factors and costs benefit analysis of compared alternatives, our egos, those of both lawyers and clients, and our society's love affair with pursuing vindication through courtroom justice, too often insidiously brainwash us, coloring our judgments by tending to over-optimize our chances of winning and to grossly underestimate probable legal and hidden costs alike. Of course, not only do we face challenges in meeting our duty to obtain informed consent from our clients, but we also face serious consequences if we fail to meet that high duty, consequences that are becoming increasingly severe as the law evolves. The serious consequences today of not getting truly informed consent from our clients for any course of action are several. They include discipline, including suspension or disbarment, nullification of protective terms and fee provisions in client agreements, civil liability for legal malpractice, civil liability for negligence or breach of fiduciary duty, and increased risk of client dissatisfaction. Let me address each of these consequences briefly in turn. First, as you would expect, the pertinent ethical rules and published cases on the subject make clear that a state bar may impose attorney discipline for violation of the informed consent rule. Such discipline can take the form of suspension, either temporary or indefinite, or even disbarment, for willful violations of the rule. However, while I have found cases of suspension for willful violation of the rule, it appears that disbarment is rare, absent something like an egregious conflict of interest. Also on this point, it's noteworthy that while discipline usually requires a willful act, it does not require an intent to violate the rule. See, for example, California Rules of Professional Conduct, Rule 1.0b1, and Phillips versus State Bar, 49 Cal 3rd 944 at 952 from 1989, and California Business and Professions Code, section 6077. So even mistaken violations may be subject to discipline. Another consequence of failing to get informed consent is that it may nullify protective terms in our professional services agreements with clients, such as an arbitration clause governing fee disputes and legal malpractice claims. For example, a recent New Jersey Supreme Court case, Delaney v. Dickey at 242 Atlantic 3rd 257 in 2020, refused to enforce an arbitration clause governing fee disputes and legal malpractice claims when the client's counsel failed to explain the differing fee structures and potential adverse consequences of agreeing to arbitration versus legal action in court. Analogizing to cases involving breach of fiduciary duty, the court confirmed that, in quotes, a lawyer is never privileged to exercise an advantage which will in any respect prove detrimental to his client's interests, close quotes. Another case cited in Delaney confirmed that this duty extends to material information about lawyers' fees, including fee provisions and the potential aggregate hourly fees and costs that may be incurred during the course of the litigation. In the midst of all this precedent of serious risk, it's noteworthy that a violation alone, without causing some harm, does not give rise to a cause of action for damages, though it does create an increased risk of client dissatisfaction. California's Rule of Professional Conduct 1.0b is fairly typical as follows. It provides that a willful violation of any of its rules is a basis for discipline. It provides that the prohibition of conduct in the rules is not exclusive, so that other statutory law and case law may apply. And it provides that a violation of a rule does not itself give rise to a cause of action for damages, and that nothing in the rules or comments is intended to enlarge or restrict the law regarding the liability of lawyers to others. In sum, for a violation of the duty of informed consent to lead to liability, for example, under a theory of legal malpractice, negligence, or breach of fiduciary duty, Delaney and published cases in California and elsewhere make clear that the usual rules governing breach, causation, and injury apply. And the incidence of that liability has been growing. As stated in a prominent survey article on the subject, in quotes, the informed consent doctrine in legal malpractice law is not a fad or an aberration. Rather, it is the expression of a core value of American legal ethics, which holds that clients have both a right to decide important matters related to their representation and a right to material information that bears upon those decisions, close quotes. The same survey article also describes what the cases are requiring as follows, in quotes, essentially what the plaintiff needs to prove in a case alleging lack of informed consent is that a certain fact was material and required to be disclosed, that it was known to the defendant lawyer, but not disclosed by the lawyer or otherwise known to the plaintiff, and that if the fact had been disclosed, the plaintiff would have chosen a different course and achieved a more favorable result. You can find this excellent survey article by Vincent R. Johnson, entitled The Informed Consent Doctrine in Legal Malpractice Law, at 11 St. Mary's Journal on Legal Malpractice and Ethics, 362, in 2021. It's also available online. Now that we've covered the legal landscape of informed consent, including the challenges of meeting our duty and the consequences of failing to meet it, let's turn to a couple of effective tools for helping us meet that duty. Let's begin here with what we all know. In order to earn and obtain a client's informed consent to a plan for addressing a dispute, it is incumbent on us to identify and disclose appropriate information about reasonably available forms of alternative dispute resolution, or ADR, and compare them with the other usual options of, for example, litigating in court or negotiating an early settlement. Today, every litigator knows, or should know, that ADR needs to be outlined and discussed at the outset of, and sometimes again during, any civil litigation, in order to meet our high duty to our clients around informed consent. But there's not clear consensus exactly what that entails. I submit, as a matter of common sense, that this overview and discussion needs to consist of at least the following, and I believe that this is borne fully out in the materials that I cited earlier and any research that you might conduct on the subject of the informed consent rule and the consequences of failure to meet it. First, disclosure of any reasonably available path or method that may serve the client's best overall, not just legal, interests. Second, description of how each works, likely legal and hidden costs, and plausible advantages and risks. Third, comparison of the above features for each path, including early settlement, negotiation, litigation, and methods of ADR. And fourth, discussion, including client Q&A and counsel's recommendation or recommendations. Of course, review with clients of some points can be truncated as appropriate based on known realities of any case and a client's already communicated priorities sometimes. But it helps both counsel and client immensely for counsel to have gone through the mental steps of this approach in advance to assure that important considerations have not been overlooked. To this end, I like and recommend starting with a table chart that includes across the top the different or optional paths that reasonably might be considered, and down the left-hand side, a series of questions reflecting factors that may be important to earning the client's informed consent. Here is an example of such a table chart for a typical civil dispute. You can see that across the top, I've identified alternative methods, options, or paths to be considered. Often, these include not only typical dispute resolution processes like litigation, arbitration, and mediation, but also other paths like negotiation, or in some cases, do nothing, as may be appropriate. My choice of questions or factors down the left side can vary, but at least in the dispute resolution context, it usually looks something like what you see here, at least in my practice. As you can see, I then check or color in each box in the chart with how I think each factor applies and compares to each of the potential paths, preferably from the client's likely perspective. On this PowerPoint illustration version or slide of the table, green background or plus signs are favorable, red background or minus signs are unfavorable, and gray background or question marks essentially communicate or say, it depends, and so may require some discussion. The approach enables a comprehensive review of paths and factors that both my client and I can discuss and follow. Personally, I find that the use of this kind of chart, even if I construct it much simpler and on the fly sometimes, helps me as counsel to see and not miss important considerations, while it immensely informs my clients in a way that helps them discuss, understand, and ultimately make the all-important decision about the best way or ways to proceed. Naturally, this chart is subject to my own views on what methods of resolution to include, what factors are important enough to compare, and what values to impose. If you try out this approach, you will and should choose what makes the most sense for you and your client to consider and discuss. We will cover some of the particular comparisons and values a bit later in the program, but for now, let it suffice that there is a lot of room for judgment and potential disagreement in the alternative methods, questions, and values chosen. But the important takeaway from this comparison table is that whatever you decide to include, and however you choose to value it, just doing this kind of exercise for and with your client can deliver real value for you both. As you can see from my comparison table, I've included as paths negotiation, litigation, arbitration, and mediation, and attempted to compare them across all factors. Next, I'd like to introduce to you another ADR-like path that, in many cases involving limited stakes, as we defined that earlier, is worthy of considering, discussing with your client, and even recommending more often than you might think. That path is neutral-driven resolution. So what is NDR, neutral-driven resolution? It is an innovative, efficient, just, and inexpensive or affordable form of ADR in common stakes civil disputes that arguably keeps the best elements of our legal justice system and discards or controls those elements whose costs absurdly exceed the difference they typically make in final outcomes. In short, NDR can deliver real, economically rational justice to parties where litigation in any form is simply too costly to do so. NDR in its purest form delivers binding justice via an adjudication that is similar to an arbitration award, but it also can take the form of mediation, both forms differing procedurally from traditional arbitration, mediation, and courtroom litigation by enabling a neutral-driven investigation of the dispute instead of investigation driven by competing lawyers or competing lawyer teams. And in that one simple difference lies extraordinary savings in legal fees, time, duration of the process, stress, relationships, and reliable justice for all parties. Here's how it works. There are 3 basic and 2 optional steps in the binding adjudicatory version of NDR. There are also 3 basic steps in NDR mediation. Both processes start with the same first 2 steps. Step 1. The parties must choose to agree in writing to use neutral-driven process instead of adversarial process. And just like in arbitration or mediation, the parties together select a neutral, also known as an arbiter, who has the right kind or kinds of legal expertise to investigate, analyze, and either mediate or decide the dispute as the parties have agreed. Often at the time of selection, the neutral arbiter can quote a fixed fee for his or her anticipated work that is a reasonable fraction of the financial stakes. You may ask, how can the neutral judge or arbiter quote a fixed fee? After all, one of the well-known challenges of litigation and other dispute resolution is that the work that will need to be done on both sides is open-ended and variable, as opposing lawyers seek out the true facts and law of the case and participate in legal process, which includes advocacy and maneuver for advantage. In NDR, however, opposing lawyers act as advisors or spokespersons only, and formal discovery is replaced by practical, neutral conducted and neutral controlled investigation. So the neutral can predict, control, and limit his or her workload based on how much money is at stake in the dispute and what he or she foresees as reasonably necessary investigation in search of the factual and legal truths of the dispute. In short, the scope of work becomes predictable and controllable, with all investigation focusing on truth-seeking as opposed to process, advantage-seeking, and gamesmanship. This and the savings potential in NDR are both easily seen in the following pie chart. In this chart, the workload of litigation is depicted by the whole pie on the left, divided between the efforts of opposing parties A and B and their attorneys, with the total workloads of each party divided between their own truth-seeking activity and all other activity necessitated by litigation's procedural rules and process, necessitating advocacy and maneuver. As you can see, the pie shows 2/3 of each side's total workload as process-focused activity, as opposed to being truth-focused. This allocation is based not only on my personal experience, but on my personal investigation of numerous legal bills and lawyer interviews, consistently revealing that no more than about 1/3 of our lawyer time in most civil cases is actually truth-focused, while at least twice that owes to all the other work that litigation requires and fosters. So by now, you know that the second step in NDR is that the arbiter proactively investigates the facts and law of the dispute instead of relying on what opposing counsel choose to present and argue following formal discovery and after largely duplicative legal research by both sides. In NDR, the parties, for their part, have to cooperate fully and promptly with the neutral's investigation, including any request for information, records, witness interviews, and anything else within reason that the arbiter asks for. Failure to cooperate is subject to sanction by the arbiter in the form of adverse inferences, just like those a courtroom judge could order. The third step. In NDR mediation, the third step is simply a mediation facilitated by the arbiter mediator or arbiter acting as mediator, typically with no binding outcome. Mediation is also an optional third step in the binding version of NDR if the parties choose to include it. Otherwise, the third step in binding NDR has the arbiter, 1, tentatively decide the dispute in a written opinion with explanation. 2, invite feedback from the parties. And then 3, either amend or finalize his or her decision. If the decision is binding, the parties must comply or face judicial enforcement at the expense of the non-complying party. The parties in a binding NDR process may also agree in advance to an optional right to appeal. Here, a disappointed party does so by requesting that 2 additional neutral arbiters review the investigation and findings of the original, with the majority vote of all 3 arbiters final. The appealing party pays for the reviewing arbiters so that appeal only takes place if the appeal is important enough to that party to justify its costs, and if the appealing party believes the original decision appears so plainly wrong or biased that any 2 other objective and reasonable neutral people would likely agree to overrule the initial decision. In this NDR process, there are no pleading wars, law in motion, briefs, depositions, discovery wars, maneuver, endless coordination of opposing teams' schedules and availabilities, trial prep, or formal trial. Perhaps the best way to think of NDR is as a kind of settlement agreement to a process rather than to an amount. In that way, it is analogous to arbitration, though not governed by local arbitration statutes unless the rules of the NDR process are structured to so comply with local arbitration statutes. NDR, in fact, has history. Its ancestors include neutral fact-finding processes in judicial proceedings, dispute resolution boards in large construction projects, ombudsmen used to review and reverse governmental abuses of authority, and even the judicial investigative approach of European civil law, to name just a few. But none of these ancestors have molded neutral-driven process into a full-blown alternative dispute resolution process for common civil disputes. So why include NDR in an MCLE hour about informed consent? I have done so because I believe that NDR is a new and potentially invaluable tool for us lawyers to assure that we have adequately informed our clients of all pertinent options and considerations in their consenting to a course of legal action. So how can we use NDR in this context? The answer is pretty simple. We introduce it and describe its pluses and minuses like we would any other alternative path that may be available. And one way of doing that comparison is to include it in our comparison process and our comparison table. For example, like the following. In this version of the comparison table of methods or paths, I've included NDR as the last column, making it easy to discuss and compare with the other methods. It's very important to note at this point that just including NDR as a possible path for resolution does not mean that you are recommending it, just as including litigation here does not mean that you are recommending it. Nor are the different methods here mutually exclusive. In some cases, one could reasonably choose to propose or prosecute one of the methods, and if it is rejected or otherwise fails, proceed with another method. The primary values in including any and all of these paths in discussion is that comparing them does 3 very valuable things. First, it helps assure that we as legal advisors don't overlook important factors in the client's decision-making process. Second, it helps our clients to better understanding and perspective that enables them to make better, more informed decisions at this all-important decision-making stage of legal representation. And third, it minimizes the risk that a later disappointed client could successfully claim that his or her attorney failed to meet this highest of ethical duties to enable an informed decision. Having said that, let's go back and take a look at some of the comparisons that our table enables. For example, a question that most savvy clients will ask, and perhaps all should ask, is number 1 on this table. I've kept it abbreviated here with the question, cost makes sense, which is short for the question, do the expected legal and other costs of this path make economic sense in light of what is at stake in the dispute? In the case of limited stakes disputes, the answer for litigation will usually, if not always, be no. And that's reflected here. The same is probably true of arbitration, which we practitioners know is essentially mini-me litigation without appeal. As for mediation, the answer depends. If successful, mediation stands a good chance in most limited stakes disputes of having costs that make sense relative to stakes. If unsuccessful, however, mediation may simply prove to be an additive cost in the whole litigation process. In contrast, whether either a negotiated settlement or NDR process, which is also a form of settlement, both legal and hidden costs of the path taken are almost certain to make sense relative to what's at stake. In the case of both, the parties get to forego all the formal discovery, procedures, time, and stresses of litigation, which is highly likely to keep all costs at a reasonable fraction of what's at stake. The paths of negotiation and NDR also fare relatively well in comparisons of how much time the path will take, and in turn, how distracting it will be to parties who almost always would rather focus their time and energies elsewhere. Again, mediation's answer depends. As we all have seen quick mediations that settled cases within a month or two, and long drawn-out mediations that have spanned many months and required substantial discovery and briefing in advance. From the table, you can also see and discuss with your client where and when litigation may make more sense than any other path, such as when the parties are unlikely to be able to agree on any other path. That does not mean, however, that it wouldn't make sense to at least propose a form of ADR, including possibly NDR, to find out if agreement to an alternative and more mutually economic process may be possible. Moreover, I have often found that just proposing a clearly more rational path, even when rejected, can be a powerful communication of strength and belief, that it says much about both the proponent and opponent, that it can sometimes force some rethinking on the other side, and in any event, usually proves helpfully informative about an opponent's real belief in the merits of their case and their real agenda in litigating. Finally, I love how this explicit comparison approach helps an attorney and client compare a decision to negotiate and accept an early settlement with any of the other action paths. Early negotiation clearly is desirable to save a relationship, minimize costs, and save time. But it can come at serious potential loss of ultimate justice and fairness for want of robust investigation and discovery into the true facts, and the lack of an eventual neutral adjudication that vindicates a party or sets helpful precedent. By the way, as a blatant plug for considering NDR, note that NDR delivers the same desirable benefits as a negotiated settlement while preserving reasonably robust investigation and neutral adjudication on the merits of the dispute. In short, in some situations, NDR may do a better job than a negotiated settlement agreement at delivering real and economically rational justice to a client. The overall key point here, however, is not which path is better in a given situation, as that will vary and can only be decided after analysis and disclosure and discussion. But rather, the key point is that this kind of disclosure, comparison, discussion, and understanding between client and attorney is potentially invaluable to both, no matter what decision the client ultimately makes. It is no wonder that The ABA model rules and an increasing number of state rules are moving to explicitly require comparisons of alternative paths and evaluation of their benefits and risks in the context of meeting our ethical duty to obtain informed consent. While NDR is an important solution to what I think of as the limited stakes justice gap in our society, I recognize that it is not right for all situations. And indeed, there are many circumstances where it should play little or no role in analyses of informed consent and related attorney-client discussions. Here are examples of where NDR does not fit. When one side simply won't agree to NDR for whatever reasons, whether from baser motives like greed, vengeance, advantage, power, or arrogance, to relatively innocent causes such as unfamiliarity, mistrust, or mistaken judgment. This is especially likely in tort injury claims and other disputes between or among strangers, or in marital and family law disputes because of high emotional or financial stakes. Finally, NDR will not work in any relationship where one side is inherently suspicious or counseled to be suspicious of and close-minded about anything that the other side might suggest. In other words, a knee-jerk reaction, sometimes referred to in literature as the not invented here syndrome. Similarly, NDR does not work where one side's attorney is not client-centric. In other words, is unable or unwilling to put the best overall interests of the client above incentives to earn legal fees or promote one's own experience base and reputation. I know that most attorneys find even the thought that attorneys would do this as repugnant, but I believe that with any experience in law and litigation, each of us can recall situations where our opposing counsel was not client-centric, or perhaps in some cases, someone we were working with or for. Of course, if parties are able to settle early on some principled and mutually dignified basis, and before starting down the lawsuit path, no form of legal action or alternative is needed. Also, whenever perceived stakes are so high that adversarial process is worth its many costs, in other words, when stakes are not limited, NDR may not make sense. Without limiting the possibilities, this category of disputes probably includes those over high dollar values, critical intellectual property rights, bet the company existential disputes, threatened loss of professional licensing necessary to pursue a livelihood, and most child custody, domestic violence, and other comparably important family law disputes. When a crime is charged, the appropriate venue must usually be the court system. Our criminal courts have the potential to impose punishments ranging from fines to incarceration or worse. Upholding an accused's rights to a fair trial, a jury of one's peers, proof beyond reasonable doubt, and a vigorous defense are fundamental constitutional rights in this context, as we are all so well aware. While NDR can deliver a fair, unbiased, and equitable forum in civil disputes over limited, money-measurable values, criminal cases are, by their nature, almost always high-stakes matters involving life or liberty. When an indispensable third party or critical non-party witness will not cooperate, NDR may not be a good solution. Only courtroom judges and other statutorily authorized officers, like arbitrators, can issue subpoenas to compel uncooperative non-parties to testify or produce records in a legal dispute. NDR, which is legally only a form of settlement between parties who agree to use and be bound by its process and outcome, does not at this time have such authority. When a party needs immediate, equitable, non-money relief that has the force of law, such as a temporary restraining order or preliminary injunction, only a court can issue and enforce such an order. Finally, if the law prevents using NDR, for example, when considerations of public policy prevent otherwise willing parties from effectively agreeing to a non-judicial solution, NDR is not worth pursuing. For example, Congress and many legislatures sometimes are so solicitous of the rights of those perceived as disadvantaged in American society that consumer, employment, and other laws can discourage or prevent perceived victims from availing themselves of fair, efficient, and practical process outside the adversarial system. As you can see, enough legal disputes still require traditional lawyer-driven process that NDR, even with numerous advantages or benefits in many circumstances, will remove only a modest percentage of the total number of cases from courts. On the other hand, most civil legal actions in the United States are fought over limited money stakes and end up consuming most or all of those stakes in excessive legal fees, related expenses, and hidden costs. Consequently, whenever parties and their counsel in limited money stake situations can agree at the outset of a relationship or dispute to try NDR on for size, there is every reason to believe that the fit may be good, potentially delivering more real justice and satisfaction to the parties and to their client-centric counsel. Before I close, I would be remiss in my introduction of NDR if I did not also mention a couple of additional, what I call moral benefits of considering NDR as a potential path to dispute resolution in cases where it may or will make sense to do so. I think of these additional benefits as something like a bonus, warranting at least a footnote that NDR's benefits do not end at the borders of ethical rules compliance. In short, using NDR to do right by your client also looks good to your client. And looking good feels good. For example, it looks good and feels good when we as attorneys identify paths forward that offer costs proportionate to what's at stake. It shows that we're creative, willing to think outside the box, and more interested in our client's bottom line than our own, what many of us call being client-centric. For the same reasons, it also looks good and feels good when we attorneys are willing to suggest such a path to our client. It also looks good and feels good when we attorneys are willing to suggest to an opponent that the parties take such a path. In this context, we're making a strong statement of belief and competence that we're willing to let the chips fall where they may in a simple and efficient, truth-finding, truth-focused process, just as we dare the other side to do or fail to do the same. Moreover, because proposing NDR is in essence a form of settlement proposal, but one to a fast, fair, and efficient process rather than a specific result, it challenges both opposing counsel and his or her client to think and talk about its implications and how best to reply, which in turn should reveal useful insights into their actual beliefs, as opposed to the typical bluster that we may encounter constantly in negotiations. And if accepted, the suggestion or proposal probably will lead to a better net result for both sides in common limited stakes disputes. Lest you think that this kind of benefit is hypothetical and imaginary, and wonder how it might play out in real life, let me share with you two quick case studies from my own practice as general counsel of our family farm in California. In one case, I was stuck in a stubborn negotiation with counsel for a former employee suing for discrimination based on national origin. There was well less than $200,000 at stake, but the plaintiff's case seemed very weak from our side's HR director and department manager's perspective. So we were offering only a nuisance settlement. When negotiations hit impasse, I suggested that we use NDR to resolve the case. I proposed it to opposing counsel. In other words, both sides would let a mutually chosen neutral arbiter investigate and decide who was right and what the outcome would be. I felt that this was a strong position to take, that if accepted, it would prove out to be economic, even if we lost, and that the plaintiff's reply would help us judge whether the plaintiff was simply trying to extort us or really and deeply believed he had been wronged and had some arguably credible evidence to support that claim. This offer proved to be a game changer and immediately broke the impasse. The other side accepted the offer. We quickly chose a neutral arbiter who quoted a flat fee of $12,000 to investigate and decide the dispute based on witness interviews to be conducted and access to the pertinent employment records. Since the farm was on the hook for the arbiter's fee due to a pre-existing arbitration agreement between the parties, we reassessed our risk on our side of the table and added that amount to our settlement offer, which was accepted. I know it helped us complete that settlement, that both we and the other side had made a principled statement of commitment to an expedited, neutral-driven process and outcome that would have let the chips fall where they may. By way of comparison, when the same kind of scenario arose in another case where the plaintiff alleged discrimination on the basis of sexual orientation, I made the same offer. The plaintiff this time refused it. And so we stayed firm with a lowball four-figure nuisance value offer that the other side had earlier scoffed at, but which they meekly accepted a week later. Again, our willingness to let the chips fall where they may in a fast, fair, and efficient process communicated genuine strength, belief, and resolve, while the plaintiff's failure to match that revealed the lie and the intended extortion in plaintiff's case and strategy. Finally, it also looks good and feels good in transactional contexts. For example, contract writing, to discuss or suggest specifying NDR as a preferred method of mediation and or final dispute resolution in any disputes that may arise out of the particular contract, or perhaps any disputes that fall into a certain value or stakes range. In this context, as above, just identifying, suggesting, and or possibly proposing such a path reveals our client centricity and much about the person or entity with whom our client plans to deal. Not to mention how the other side is likely to behave if and when a dispute ever does arrive. I hope you have enjoyed, or at least found worthwhile, this slightly irreverent and practical take on the informed consent ethical rule and a couple of specific and useful new tools for meeting our high ethical duty to obtain informed consent when helping our clients to decide important legal paths or strategies to pursue. If you have any questions or even comments about either the dispute resolution methods comparison table that I advocate here, or about the specific alternative dispute resolution method of neutral-driven resolution, please don't hesitate to share them with me via an email to rob.christopher@justresolve.com, or if you're a baby boomer or otherwise an old soul like me, you can even do an old-fashioned phone call to my mobile phone at 408-839-8581. I'd love to hear from you. And if you're really interested in either or both tools and just want to learn more, check out my website, www.justresolve.com, which includes a free and useful total costs of litigation calculator for comparing likely litigation costs against likely NDR costs in most common disputes. Or just check out my book, Just Right: How Neutral-Driven Resolution Can Close the Gap in American Civil Justice, available on Amazon.com and BarnesandNoble.com. In all events, thanks for attending this program.